call Dennis O'Rourke.
Thank you, Mr Speaker. New Zealand First is also happy to support the bill, particularly because it improves accessibility and understandability of legislation for the New Zealand public. And I first want to, before going any further, to acknowledge the work of the Regulations Review Committee, which I think has done a really good job with this piece of legislation. And it's high time, of course, that there is a modernisation of legislation governing the drafting of legislation and concerning the functions of Parliamentary Council. As we know, the bill principally would replace the Statutes Drafting and Compilation Act 1920, the Acts and Regulations Publication Act 1989, and the Regulations Disallowance Act 1989. And most importantly, I think it provides for a 3-year program of systematic revision of legislation. That's a very welcome move and something which probably should have been done a long time ago. The bill would also alter the functions of the Chief Parliamentary Council, and in particular, the Chief Parliamentary Council will be required to publish legislation in electronic as well as printed form, and to issue official versions in electronic and printed form. And that will be very welcome to people who these days, and I think it's the majority, who find their way through legislation through electronic means. So this just brings that situation up to date and is most appropriate. I particularly wanted, however, to make some comments about the part of the Act relating to revision bills. And the purpose, as we know, is stated in section 29(2), which says that the purpose of the revision is to reenact in an up-to-date and accessible form the law previously contained in all or part of one or more acts, but, except as authorised by that part, the revision is not intended to change the effect of the law. And I think that's a very important issue, which I think has been well addressed by the committee. However, the revision program in section 31(2) is, as I've already said, I think for me the crux of the whole thing. And it includes such important things as revision of the whole or part of one or more acts with the ability to combine or divide them as may be appropriate. And in 2C, it's in 31(2)(c) refers to the omission of redundant and spent provisions, which will also be useful, and in F to include new or additional purpose provisions, which will be helpful for the public as well. Most importantly, I think in I to make minor amendments to clarify Parliament's intent, and that, of course, that word minor is open to interpretation, but I do believe that it's appropriate to have it there. In J, it allows the updating of monetary amounts and that kind of things, which is just common sense stuff. Mr Speaker, it is important, however, that in section 31(3), the revision bills must not change the effect of any statute. However, that doesn't mean there won't be any substantive changes which would still be possible. Therefore, great care is going to be needed, I believe, to preserve the integrity of the acts which are dealt with under this legislation. Something which I think the House will need to be careful of when it looks at revision bills as they come through in the future. So in other words, we're still going to have to be vigilant. Section 34(2), Mr Speaker, repeats the requirements not to change the effect of any statute, but that is qualified by section 34(3), which says, and I will quote, a revision bill must not change the effect of the law except as authorised by subsection 2(1) or J, which I have already referred to. So there is a degree of conflict and some confusion between sections 31(3) and 34(2), which state that there should be no change to the effect of any statute, and section 34(3), which says that there may be change to the effect of a statute if expressly stated. Now, I note that the committee has said that for this purpose it has inserted the new clause 33A in relation to minor policy changes to revision bills, and it considered that the bill as introduced might cause confusion about the relationship between the changes properly made using the revision powers and the changes made by members of Parliament during the passage of a revision bill through the House. And that's the dilemma, of course. They go on to say that they considered that the bill should make the distinction clearer, and for that reason they have put in section 33A. And Mr. Chairman, Mr. Speaker, section 33A(1) says, if you just give me a moment, 33A(1) says a revision bill as introduced must not contain any proposed change to the effect of the law unless the amendment is authorised by section 31. And it goes on to say in subsection 2, nothing in this Act affects the powers of the House of Representatives to amend a revision bill for any purpose and to pass it with amendment. To me, Mr. Speaker, that new provision, section 33A(1), does not improve the problem. It simply restates the dilemma without actually improving anything. So although I appreciate that the committee did want to clarify the situation, I don't think they did it with that particular provision. Mr. Speaker, I believe it would actually have been better if sections 34(3) and 33A(1) were deleted altogether and we were left only with section 33A(2), which, I repeat, simply says nothing in this Act affects the power of the House of Representatives to amend a revision bill for any purpose and to pass it with amendment. It would be quite sufficient for that to be there, and those other sections I referred to need not have been there at all. However, that's a relatively minor matter. I would have preferred it that way, but it's not something that I think would cause New Zealand First to vote against the bill or at this late stage attempt to change it further. I just think it would have been a better way of going about it. Mr. Speaker, I wanted to just go on briefly and mention now the functions of Parliamentary Council, and to note with approval that Clause 58 of the bill has now been divided into the three new clauses, 58, 58A and 58B. That's very wise. It does make things much clearer to do that. And, Mr. Speaker, we also welcome the new subclause 1H of Clause 58, which refers expressly to the rights of the public. And it does say in that clause that the functions of the PCO are to examine local bills and private bills and to examine the members' bills that the Attorney-General directs to be examined and to report to the Attorney-General on the effects of bills examined, in particular on whether they affect the rights of the Crown or the public and on their relationship to other legislation. I think that's a very good provision indeed. Advice on that has been often absent in the past, and I think that's a very good provision which New Zealand First supports wholeheartedly. With regard to the appointment of the functions of the Chief Parliamentary Council, we completely agree with the need for that person to be legally qualified in New Zealand or in a similar jurisdiction, and the same provision for other Parliamentary Council as well. Mr. Speaker, New Zealand First has no issues with any of the other provisions of the bill or with the Select Committee amendments that have been proposed, and will therefore be very happy indeed with the reservations that I made to vote in favour of the bill as amended.
Call Ian McKelvey.
Thank you, Mr. Speaker. Anyone